That seems to be very sensible. But is the rendering of a property useless the same as the Commonwealth taking it?
It is, David. Judges in the High Court have used the word sterilisation or loss of a reasonable user. If a person's property is not actually acquired by the particular law, by a sort of a resumption law, but instead the government, state or federal, just prevents any user of it, what's the difference? You've lost the right to use your land. You still have the title to it, but you don't enjoy it. So that's why it's important to see that both the sterilisation or the loss of reasonable user is in effect an acquisition.
Mr. King, you're doing this on a pro bono basis. Otherwise you're not being paid, as I understand it, the same as the other case, the electoral case. Why are you doing this?
Well, look, I think that it's terribly important that where a proper case arises which involves the public interest, that lawyers should be prepared to act responsibly and ensure that the argument is heard in the courts. It's then for the courts to decide whether it's right or wrong. But in the case of Spencer, for example, it wasn't just Peter Spencer's problem. Farmers all over the country have been suffering, some perhaps less than him, others possibly more, we don't know, because they've had their land locked down to achieve a benefit to the Commonwealth and to prevent it from incurring expense at a time when the resource giants of this country are reaping billions.
Mr. King, you're appearing in the High Court defending the farmer, Peter Spencer, acting rather for the farmer, Peter Spencer, who was sitting up a pole on one occasion and threatening to starve himself to death because of the way he was being treated. How is that case proceeding?
It's proceeding apace. The High Court has held that Mr. Spencer has an arguable case that ought to be considered by the Federal Court, which initially struck out his claim. And 7-0, the learned judges have sent it back to the Federal Court to have it decided. The most interesting aspect of the case at the moment is the extreme reluctance of the Commonwealth and state governments to disclose their documents, which is in the discovery process, to ensure that we can prove the informal arrangements between the Commonwealth and the state which deprive Mr. Spencer of his property. It's a very important principle in the case. Peter's 52-day hunger strike wasn't just a publicity gesture. He did it, you may recall, right at the start of the Copenhagen conference. Now, there was a Danish flag on his rostrum. There was a couple of Australian flags and a few other things. But he was concerned to show not that he's against the environment, but rather that he's a victim of laws which are designed to, or said to be designed to help the environment, but in fact harm people like him. Why should he suffer when there is a public interest not only in compensating someone such as him, but also in addressing the environmental challenge? So I think that at the base of his concern are the protection of his property rights and the loss that he suffered as a result.
Effectively, he's being used to satisfy the quota under the Kyoto Protocol, is he not? He's not allowed to effectively use his farm to produce income so that we can, as a nation, satisfy a quota which the government has agreed to. But does not the Constitution provide that if your property is taken from you, that you're entitled to just compensation?
You're exactly right, and that's what the High Court pointed out to the Federal Court. However, the complication in this case is this, that it was not a Commonwealth law but a state law which had the consequence of actually locking down his land. The Commonwealth received the benefit of the locking down of the land because a carbon sink was created, which was then treated as a benefit for the Kyoto Protocol reporting purposes. So the Federal Court had held there was no law, quote unquote, with respect to the acquisition of his property. But the High Court pointed out that in this particular case the Commonwealth had paid the state to pass the law. There was a Commonwealth law and a state law and money passing hands. Money for laws, cash for measures,
So you're
was the way I summarised it. And it seems to me that the Commonwealth ought not to be able to do indirectly what it could not do directly. It cannot use the state for its own improper ends.